All right, we're going to go ahead and get started. Thank you all for joining us for today's webinar, What's New in Immigration Law? Changes to the Public Charge Rule, which may affect your students. This webinar is hosted by Florida Literacy Coalition and made possible through the support of the Florida Department of Education, Division of Career and Adult Education. All right, so with that, I would like to introduce you to our presenter today, Alice Burgos, who is an attorney at Magnolia Immigration Law. Okay, Alice?
Hi, my name is Alice Burgos. I'm an immigration attorney at Magnolia Immigration Law. We are a full-service immigration firm, so we practice all areas of immigration. I'm humanitarian, family, business, employment, we do it all. Today we're going to talk about the overview of the new public charge rule and the changes that went into effect. So this new rule applies to anyone applying for a green card. Whether they're applying within the United States for a green card or whether they're applying at the consulate, this rule applies to them. So any application that was filed on stateside within the United States on February 24th, 2020, or after, this rule is going to apply to them. Also, those who are applying at the consulate whose interview is after February 24th, 2020, this new rule is also going to apply to them. So what immigration is determining is whether or not the applicant themselves is likely to become a public charge. So in the past, and still currently, they used to look at just the household members or the sponsor or petitioner who is sponsoring this person for a green card. They used to look at them and determine whether or not they made enough income to support this, who their beneficiary was of their application. They're still going to be looking at whether or not the person petitioning and sponsoring them makes enough income, but now they're also going to be looking at the immigrant themselves and whether or not they are self-sufficient. So immigration is going to be considering many factors, and they're going to be assigning those factors as positive, neutral, or negative. So in order to get a green card, the applicant must have more positive and neutral factors than negative factors. So here are a few of the main overview topics that they're looking at. There are many factors within each category, but these are just a few of them. And we're going to be going over each of these separately today, and then we're going to talk about the English proficiency requirement and what that is all about. So they're going to be looking at first whether or not they've received any public benefits, what their health and health insurance looks like, income, their ability to work, assets, education, skills, and honestly, many more other factors, but these are the main 5. So the first is public benefits. So what public benefits are going to count against the public charge rule? So supplemental social income, cash assistance, food stamps, federally funded Medicaid, any type of public housing program, and then temporary assistance for needy families. So those are the programs that are definitely going to be a negative factor towards this evaluation. What it doesn't include is emergency Medicaid if you received Medicaid under the age of 21, and if you received Medicaid while pregnant and up to 60 days after pregnancy. It also does not include unemployment, check, and any workers' compensation benefits that have been received. So remember, for public benefits, it's whether or not the immigrant who's applying for the green card has received the public benefit. It doesn't mean that their children can't receive benefits. So if they have United States children, US citizens, then they can receive whatever public benefit that they qualify for. It only affects them if they themselves receive these public benefits. In this evaluation, they're going to consider the withdrawal of the public benefit as a somewhat positive factor. So if they're currently receiving these benefits, we might have them withdraw from those benefits in order to apply. However, the public charge rule and the determination that an immigration officer is going to make is discretionary. So they're only human. They are going to still think about whether or not they received these public benefits. So let's talk about health and health insurance. So if you don't have any health issues, that's going to be a positive factor. If you have chronic health issues, that's going to be considered a negative factor. How we are going to mitigate that is by showing that they're receiving treatment, that they're going to the doctor regularly, that they're taking their medication. Another thing is health insurance. If they have health insurance, then that's going to be a heavily weighted positive factor if it's private health insurance. If they receive health insurance through Obamacare, it's going to be a positive factor. So I know that a lot of them are scared to get health insurance through Obamacare, but that's good for them. Please do that. The only time where it's going to be considered negative towards them is if they have no health insurance at all. So income and the ability to work. So immigration is going to look at how much is your household income earned and how big is your household size. And we are striving for them to be 250% over the federal poverty guidelines. Income includes money that's made with or without a work permit. So if they are currently legally working, that money is going to count. However, in order for us to be able to use those funds towards this calculation, they have to pay taxes. So they need to file for an ITIN number and they need to file taxes every year. The IRS, and it's important to stress, the IRS does not work with immigration. One does not talk to the other. And then they're also going to talk about the ability to work. They want to see, what does your job history look like? What are your potentials? The next area is assets. So this includes assets anywhere around the world. So first they're going to look at your household home. So this is not whether the home is in the immigrant's name. It's whether it's a household home. So if the immigrant is a child that they're applying for a green card application for, then their parents' home would count towards this equation. If it's a U.S. citizen spouse sponsoring a beneficiary, their spouse's home is going to count towards assets. For vehicles, it's only 2 or more vehicles, and that does have to be in the immigrant's name. The first vehicle doesn't count because you're not going to, it's not liquidable cash. It's in the assumption of immigration that you're not going to sell your only vehicle for money. Of course, boat ownership, land ownership, and money in your bank account, stocks, any type of financial resources. They want to see that you have cash that you can liquidate. So education and English proficiency, and I have another slide on English proficiency that I'm going to go in a little bit more detail. So if you have a high school degree, that's a positive factor. A college or other type of degree is a positive factor. If you're under the age of 18, but you're in school, that's a positive factor. It's important to remember that this is not only for adult immigrants that are applying for a green card. We have to do this public charge rule for a 1-month-old. We have to do this public charge rule for an 86-year-old. There is no type of age limit on whether or not we have to go through this analysis. So if you're under the age of 18 and you're going to school, that's a positive factor. If you have specific job skills, that are going to be a positive factor. If you have no job skills and you've never worked before, that's a negative factor. English proficiency is a positive factor, and I'm going to discuss that a little bit more on the next slide. And then any certifications of any types of courses or professional development that you've done is going to be helpful. And then if you speak additional foreign languages besides the foreign language that's native to you, then that's going to also be a positive factor. So let's talk a little bit about English proficiency. So immigrant has not defined what is English proficiency. In the final rule for the public charge is over 200 and something pages. In reading over the comments by the government and the questions that were submitted when approving this rule, I got the sense, and what we're legally going to argue, is that really what it means is that they have really been exposed to English and that they have some type of English skill. And that's what we're arguing at this time. So the rule just went into effect on February 24th, 2020. So we've only had this rule for a couple months now. And green card applications are taking about 18 to 24 months to see an interview. And so we have not even gone to or actually adjudicated any cases, no immigration attorney across the country has yet, for cases that are filed within the United States that this rule applies to. And so really we're throwing the kitchen sink. We're trying to get as much positive factors as possible because we don't know on their scale where things are going to lie for each factor. So none of this has actually been adjudicated. So we're just running off of theory and based off what the final rule says. So ways to prove English proficiency. One way to prove it is having them take a test. So I know in Orlando, we have partnered with the Adult Literacy League, and we're sending our clients the Adult Literacy League to either take a test or take classes. I know that the Florida Literacy Coalition also has this ability to do that. And so right now, they are probably going to more of an influx of immigration attorneys sending their client their way in order to get tested. Or if we can show any proof that they received language or literacy classes, that is helpful. Whether or not they have a high school or college degree, transcripts of courses taken in English. So if they went to high school here or college here, then that's going to be helpful. Part of our concern and a lot of comments that we made and before this rule went into effect is whether or not this was discriminatory, requiring English for a green card. And the government has responded that it's one of many factors. So each one of the factors that I have talked about is one of many factors. It's not the sole factor. So you don't have to speak English to necessarily have enough positive factors to pass the public charge rule. And because of that, English proficiency in itself is not going to be discriminatory against the immigrant. So that's really important to think about. However, at this time, since we are not sure how they're actually going to end up weighing these different factors, we are really sending anyone who has not had any classes in the English language or has not been tested, we are sending them to get tested and take classes. So this rule does not apply to applicants applying for humanitarian type green cards. So if they're receiving their through asylum or through VAWA or through a U visa or a T visa, then we are not going to go through the public charge analysis. Otherwise, it applies to any type of green card application. So in summary, there is no longer a simple green card application. You have to provide proof and evidence of all these different factors. For instance, if you own a home, you need to get a property appraisal. If you own a boat, you have to get a property appraisal. Whether it's in the country or not, they need a recent appraisal for those assets. So we have to be able to prove that you have these things. We have to be able to prove income. And a lot of that is going to take strategy. Some other factors I didn't go over today is that they're going to look at whether or not they've ever filed bankruptcy before. They're going to look at their liabilities and debts. They're going to look at what their credit score is in this country or in their home country. And so these are some, and they're going to look at household size as well. Any household over 5 is automatically a negative factor. And their rationale on these factors is that if they likely don't have health insurance or they're a household over 5, they're more likely to apply for public benefits in the future. So that's kind of where we're at in this new rule. It's fairly new, but this is a good overview of how this is going to affect your clients and the type of questions that they're going to ask. Do you have any questions about the public charge rule or any question about immigration at all? I'd be happy to go over that. But one thing I do want to mention is that we, as a law firm, for us, we have put together a team of professionals that are equipped in these different areas. We are working with a property appraiser that does the whole state of Florida. We're working with certain individuals, a tax preparer that's used to working with immigrants, CPAs that are used to working with immigrants, because a lot of immigrants own their own business. So they might own a lawn care company or a handyman service, or that's how they're currently working. And even for the business income, we need to be able to show that they're not in a deficit. They might need to work with a CPA. So we put together a team of professionals that can really help turn some of maybe negative factors into positive factors. And it's really important that it's really going to be pre-planning to file your green card, as opposed to, I'm going to file my green card this month, I'm going to fill out the forms, get the documents together. And it's important to have an immigration attorney walk them through this process. Another thing to think about that they may not think about is that it's important to have an immigration attorney in their interview. The public charge rule is a discretionary rule, meaning that if the officer's in the interview and based on the officer's life experience, the officers have no guidance on whether or not they're going to make a determination if this person is going to become a public charge. Immigration has not released any guidance. They actually told the officers, just look at it and see, what do you think, and make a determination. So there's no clear guidance on this. Our goal is to have more positive factors and neutral factors than negative factors, but there is no guidance. So, it's really based on the officer's discretion, and it's going to be important to have an immigration attorney in their interview now in order to advocate for them through this public charge analysis. All right, I'll go ahead and take any questions. Nicole, if you can help me read them.
Yeah, no problem. We have quite a few questions here, so let's go ahead and get started. The first question is it considered a positive factor if they receive the ACA or Obamacare health insurance subsidies versus unsubsidized Obamacare?
Sure. So there is no difference. However, I would encourage them not to take the subsidy, only because on the immigration officer's look, the reason why they qualified for a subsidy is because of maybe lower income. So we're encouraging them to not take the subsidy, but if they really need it in order to afford it, please take it. That's kind of our stance on that right now.
All right, so our next question here is a high school degree and college degree weighted equally? I assume a degree from your home country counts equally.
So another evidence document that they're going to need to obtain is called, they need to get their education evaluated. So there's companies that evaluates foreign degrees and sees whether or not they're equal to a United States degree. So we would submit them and see what results we get back, and then we're going to use that determination. One thing to keep in mind with the new public charge rule is that every immigration attorney across the country is doing a legal brief. So not only are we submitting these legal documents and these documents with evidence, but we're also arguing each factor. And around that argument is going to be, it's going to be specific to the immigrant, right? It depends on what the degree is. How long, what classes did they take in high school? Can we pull anything out of this transcript and make it equivalent? Like if they took home ec and in high school, we might argue that they have, the potential to, work at a restaurant or something like that. We have to really get creative with these. So every single person is going to be different.
All right. The next question is, let's see. Will applicants be allotted time to meet these requirements?
So it's going to be, we're going to have them, they need to contact an immigration attorney, and the immigration attorney is going to first do a public charge analysis with them. We're going to go over what is their current condition, well, first of all, what do they qualify for? So, if they qualify for asylum or they qualify for a T or a U visa or VAWA, we're not worrying about the public charge rule. Let's say they qualify for something that's not that way and we're getting a green card through another means. We're first going to do an initial public charge analysis, and then we have to work with that person on strengthening those positives. Now, if they file their application pro se and they do it and they don't realize what's happening, while the application is pending, we can still work on some of these positive and negative factors, and then we can bring additional documents to the interview. Right now, applications for green cards that are within the state, that are filed within the United States, is taking about 18 to 24 months. So whether or not we say, hey, let's clean this up and then file, or whether or not we say, let's file and then let's work on these couple of things, is going to be really fast specific based on the immigrant situation.
All right, the next question here is, how are immigrants affected if their American children have received public benefits?
Yeah, so that's okay. It's whether or not they themselves received the benefit. If their American children received the benefit, that's fine. For public benefits, they're looking at whether the immigrant received it, not whether the household received it.
Okay, so someone here wants some clarification. I missed whether the household over 5 includes children.
Yes. So yes, the definition of household for the public charge rule is not your traditional definition of household. So it's going to be dependent on what their living situation is. So again, it's another thing that's that specific, but it does include their dependents and their children. And if their nieces or nephews are living with them, it includes them too. It depends on who they're supporting. So we need, it's another type of definition of household. It's not only immediate family.
All right.
So that's something that we'd also strategize. We would say, okay, well, can they go live with somebody else for a period of time? Change their school address to, grandma's house, or, we need to make those, did you claim them on your tax returns, right? When you did file for taxes. And that's why it's also important for them to, when they file for taxes, they file with someone who's used to dealing with immigrants and understands the public charge rule, because you don't want to claim everybody under the sun on your taxes. So it's important for them to work with somebody who understands these effects. Most tax preparers are not going to understand these effects unless they actually work closely with an immigration attorney, which is why we have trained a couple of CPAs and tax preparers that we know And they usually will consult with us if they think that something is going to be a problem. They also understand what the taxes need to look like in order for us to have a better chance of approval.
All right, now we have a question actually for us here at FLC in regards to if an attorney reaches out to us. So if it's applicable, we will be forwarding the attorneys with these questions onto the appropriate organizations. So the next question here is, do you have any literature on how to choose an immigration lawyer, like a brochure or something they can use in class?
Sure. So, I mean, I don't have literature, but if you want to email me, I can make something for you. It's important that you work. Immigration is the second most complex area of law in the United States after taxation. And I never want to learn taxation. So it's important to be within a firm that only practices immigration. There is an average of 2 changes in immigration per day. So you want to make sure that you're working with an attorney that's really keeping up with what's going on, that's active with ALA. Like my boss is on the board of ALA, it's the American Immigration Lawyers Association. That's really important because we get fed a lot of information first, and we understand what's going on in immigration because we are solely dedicated to helping immigrants. That's really my only kind of tidbit on that, is just to make sure that this person is someone who truly understands immigration and that this is their sole practice. Because if you're not all in it and you take a couple immigration cases here or there, there's so many changes so often in what's going on at, politically and in local office, that it's hard. Immigration is fully federal. We practice immigration all over the United States, and we help anybody, anywhere in the world come into the country. And that's fine. The immigration attorney does not have to be local to you. They don't have to have an office near you in order to help you. There's only 2 immigration courts in the state of Florida, in Miami and Orlando, and we all travel. So it really depends. But my one thing I always tell people is find an immigration firm where their only practice is immigration.
All right, next question. If the White House switches hands after the election, will these rules still likely continue, and for how long?
So these are pretty engraved. However, could they change? Yes, but that is going to require for there to be a notice posted, a commenting period. They're still going to have to go through the legislative process in order to reverse the rule. This is not done by an executive order. This is actually regulation in the books now. So it's a longer process. It's going to be a harder process to go through. Is it possible? Yes. We're just going to have to wait and see, but it is possible.
All right, so our next question here is, how long do immigrants have to be in the States before some of these factors are considered?
No, these factors are always considered when applying for a green card. These factors are considered even if they're not in the United States and they're applying at the consulate. So none of the factors change. They're going to just look at what's your current income in your home country and how does that convert to American dollars. What are your current assets in your home country? They're going to take a look at this in the same way. You have a bank account in your home country the same way you have a bank account in the United States. So there's no time limit of how long they need to be here. It's whenever they apply for their green card. Now, the issues become, well, I'm not applying for my green card right now, but these are still things that immigrants need to start working towards. You don't want to just start filing for taxes right when you know that you're going to apply for a green card. You need to start doing that now so we have a longer history and we can use that in our legal brief. So, yes.
All right. Some nonprofit organizations offer classes in financial literacy, health literacy, parenting, etc. Will these count positively towards education?
I would argue it. I don't know if they're going to buy it. As I mentioned, we're kind of throwing the kitchen sink. So if they have like certification saying that they took financial literacy, and maybe we can get copies of the slides and what went over in that class, then I would definitely include that in the application, especially if they currently don't have a lot in their bank account, but they're working on a savings plan or something of that nature. Then absolutely, I would go through that process and go ahead and include it and argue it in my legal brief. And that's the type of creativity that we are working with right now until we more hard rules, until we start seeing these get litigated. But please rest assured that we have, as immigration attorneys, we have our own Facebook group just on the public charge rule, and we are all working as a collective team in order to help immigrants overcome this. Just because this rule went into effect doesn't mean that getting a green card is impossible. It's just going to require a little bit more work and a lot more strategy. This public charge rule and doing this documentation in this legal brief is adding about 10 to 12 hours onto a simple green card case. And normally a green card case to file for a green card takes 10 to 12 hours itself. So it literally doubles the amount of time that we have to spend on these cases in order to make sure that they're going to be successful.
All right. We've got lots of questions here. So are any allowances being made for people who need to access assistance during the pandemic?
So there was a small period, or there's a period of time, there's a memo that came out that indicated that they're going to relax the public charge rule for a period of time. I can get you the exact date on when that starts. However, you know, we have printed out that rule and have saved it in our public charge rule, that memo, and saved it in our public charge rule folder because we plan on using it later. We don't know how much weight the officer is going to give to it, but it is existing. I suspect that a lot of these public charge rule applications, that if it's not an automatic approval, we are going to be litigating these in federal court. And that's what we have been moving towards in immigration, period. We have been doing a lot of lawsuits in federal court for improper rejections, improper denials, and we're just challenging them in federal court, and USCIS is folding. So, you know, if you know a family that's going through a rough time in immigration, it might be time to file in federal court, but we plan on filing a lot in federal court locally here. In the Middle District of Florida, Southern District of Florida, and Northern District of Florida.
All right. The next question is, the rule took effect in February. Is this the case? Is this for all cases filed before this date?
On or after this date. Basically what happened was in the beginning, when this rule came, when we found out that it was going to be finalized in January, basically we did a public service announcement. It was like, if you have been eligible to file for a green card, this is the time. And we probably filed about, in our office, probably about 25 applications on a rush within a 2-week period. And immigration attorneys all over the country were hurrying to file before this period. So any application that was received on or after the 24th, this new rule applies.
All right. How will the public charge laws affect the people who want to apply for citizenship at this time?
Sure. So the public charge rule doesn't apply to citizenship. However, if they want to apply for citizenship, now is the time, because we are hearing in the little birdies are telling us that the next plan of attack is to make citizenship harder. If there's anybody that's eligible to file for citizenship, now's the time. Why we know what the rules are, how it maneuvers, and we know that we can get approvals for citizenship right now. However, they are planning on making the test harder and the process a lot harder. So that would kind of be important to go ahead and get started right away. Not only that, fees are scheduled to go up. There was a pause in fees. So the application for citizenship used to be well, it is currently still now $725 for the application fee. That's scheduled to go up to $1,225 due to inflation, supposedly. So at this time, this rule was supposed to go into effect in the beginning of March. Because of the pandemic, they pulled the increase in fees. However, you might have heard in the news that USCIS has ran out of money. The reason why they ran out of money is because they took money that was supposed to be for USCIS and they gave it to ICE. It's not because there's any decrease in applications and that people are not applying. It's they reallocated the money from USCIS to ICE, and now they have ran out of money for USCIS. So they're going to go ahead and start uptaking those fees. So anybody that needs to apply for citizenship before the fees go up almost $500 should probably go ahead and get that done now, while the fees are what they are.
How much does it cost to have an immigration attorney represent them through the green card process?
That's going to be dependent upon attorney. I'm going to tell you that because of the new public charge rule, it used to be about $3,000 to $3,600. That was the average. That was the average amount. Now, because of this new public charge rule, we're seeing anywhere from $5,000 to $6,000 for the whole entire process. That's within the United States. That's not consular processing. The hard part is now for nonprofits that used to do these applications fairly quickly for free. With these new rules, are going to be bogged down during this process. So it's going to be really hard for these nonprofits to accept more cases at a pro bono type situation, only because they require so much more time now.
All right, the next question here is, can you amend your application over time to add income, courses taken, etc.?
Yes, so if at the time of the interview you have done other things, like you've actually finished your literacy courses, or you've gotten a raise or switched jobs, then at the interview we would bring the new evidence. The immigration attorney would introduce that evidence and, and basically amend verbally the brief on the record. All interviews are recorded. So what we say during the interview and what type of arguments we make are recorded, so we can use them in litigation later.
All right. Are there good plain language materials available for teachers to introduce and discuss this topic with students?
I can look and see. I think Ayla has some resources that talk about this new public charge rule. That's the American Immigration Lawyers Association. If they want to send me an email, I can see what I can find on Ayla. I know I have also wrote a public charge memo that kind of goes in plain English but I give it to my clients. I can also send them that. Because right now, immigrants are having trouble understanding why there's an increase of fees. They used to pay around $3,000 for an application. Why is it so much money? And so we tried to give them to teach them about the rule and for them to understand that this rule is really important to their case. And immigration is looking for any reason to deny applications, and this is a really easy way to deny someone. So we are handing out literature, so I'll be more than happy to email that to anybody who wants it. Just send me an email.
All right, and just a heads up, I'll be sharing her email with everyone after the session in the follow-up email. You'll have all this information. Okay, so next question. Will people applying for citizenship have to pay back any government assistance like food stamps, child care, etc. that they received?
Have not seen that yet. And typically if they got their green card on the old rule, technically they got a sponsor. And the sponsor would be the one who would be responsible for paying that back. And we have seen an increase on that enforcement, where if someone gets on food stamps, and they're working on making that system more traceable, right? So if you applied for food stamps, we are seeing that if someone with a green card already applies for food stamps and they had a sponsor, that they're billing that sponsor to pay back the government. But yes, and typically before it was only cash assistance. So in the past, public charge was only cash assistance type benefits. Food stamps was not a factor in that. However, this new public charge rule has expanded the meaning of public benefits, and now they've included food stamps and Medicaid and all of these other. Before it was only cash type benefits. But we have heard stories of that happening. But I also have filed naturalization applications and have gone to interviews since this rule has gone into effect, and it has been nothing. But we have heard, various stories, but it's not going to be immigration that says, hey, your sponsor needs to pay them back. It's going to be whoever's in charge of the public benefits office, whoever's in charge of that office would be sending the sponsor a bill and saying, hey, you need to pay this money because you promised to support this person, so they would not become a public charge to the United States. So that really doesn't have to do on whether or not they're United States, whether or not they're going to get approved for citizenship is not going to be determined on whether or not they've ever received public benefits in the past. At least as far as I know and as far as we've seen.
All right, to clarify, so this doesn't apply to folks who applied prior to February, correct? Are there circumstances that this will apply to anyone who has been here for a while?
Not that we're seeing right now, because this form is only done when you're applying for a green card for the first time. So that's not our understanding at this moment. Can it change in the future? Yes. Do we usually advise green card holders not to apply for benefits? Yeah. But if it becomes a source of survival, then you got to do what you got to do.
All right. Can a person with a green card still have the possibility of being deported if they have not been naturalized?
For many reasons. There's a whole slew of law that goes into whether what we call removability grounds. So when we're talking about the public charge rule in this instance, we're talking what we call an admissibility ground. So inadmissibility grounds are ways in which the government can deny someone a green card, right? Removability grounds is a different area of immigration law where if they already have a green card, if they do certain crimes or there's certain things that are involved, they can get picked up and they can still be removed. You're really not 100% safe until you've applied for citizenship. Public charge is the removability ground. However, they have not implemented public charge for removability ground to this extent. I think that currently it's my understanding that it's still cash benefits. However, can they? Yeah, they can. Can they say that this applies to people who are now? Really, it's only public benefits. So public benefits in definition in law is if someone has received public benefits more than an aggregate of 12 months out of any 36-month period. So for the removability ground, they would actually need to receive those public benefits for any 12-month period out of 36 months. So that's an aggregate. Now, keep in mind that if they receive more than one public benefit, that considers to be two. So if they receive food stamps and they receive Medicaid and they receive those benefits for more than 6 months each benefit, then that's 12 months within a 36-month period. In the past, public charge rule was barely enforced. It's not something that anyone really cared about. Now it's a different scenario, at least on the inadmissibility ground side. However, we have not seen much of a change on the removability ground side after they received their green card. However, that is the general rule. We are still kind of unclear on whether food stamps and Medicaid count for removability ground. We know for sure that cash assistance still does. It's just not clear right now.
All right. Next question is, this sounds like it may be a system in which you can get two different outcomes with two different immigration officers, since there are many judgment calls involved. Is this correct?
Yes, which is why it's there. That's why there's no such thing as a simple green card application. It's also why every immigrant needs to be represented through the green card process now. And it's very imperative that you have an immigration attorney in your interview with you, because we need to be able to take notes on we need to be able to argue the demeanor of the officer. There is a list of what we call USCIS. It's a USCIS policy manual that governs how an officer is supposed to go through an interview, what type of attitude they're supposed to have. Immigration is supposed to be benefits focused, meaning you come in, you apply for the benefit. If you tick the box on all the requirements, you're supposed to receive it. Now they're looking for any way to deny these applications. So it's more like a cross-examination, an interrogation, and it's not supposed to be. Actually, USCIS policy manual indicates that they cannot act in that way. This is not a cross-examination, this is an interview. So it's important that you have somebody there to protect you, to know when to get a supervisor involved. And that's something that an immigration attorney can do for you, is get a supervisor involved. We can say, hey, we don't like the way this is going. You're not acting appropriately. Can we please speak to your supervisor? So there's a lot of things that an immigration attorney can do that is kind of hard for an immigrant to do, because if an immigrant is we want the immigrant to be a neutral party during the interview. So we don't want the immigrant asking for a supervisor, because at the end of the day, the supervisor and the officer is still going to make a decision on their case. So we don't want you have to get aggressive back with the officer and with the supervisor. We want them to be upset with us. We don't want them to be frustrated with the immigrant. So it's important to have somebody in your interview to help navigate that process, and also take notes. We use those notes because they are a direct reflection of what happened at the time. In order to file BIA appeals, the Board of Immigration Appeals will file cases to the BIA, or even federal appeals. So it's important to have somebody that can help document exactly what happened and what questions have been asked.
All right, next question is, when are the fees scheduled to go up?
We don't have a clear date yet, but we know that it's going to be happening soon because USCIS ran out of money. So at this point, filed with the we need to get moving. We typically turn cases around depending on the type of case, but like something like citizenship, we can turn around in a week. It just depends on whether the client can get us the documents quickly and what their circumstances are, but usually a week to 2 weeks. But we're trying to get everybody to apply while we can right now before these fees go up.
All right, if you are an immigrant, do you need a green card before you apply for U.S. citizenship?
Yeah, absolutely. So depending on how you obtained your green card is going to be dependent on how long you need your green card before you can apply for citizenship. So you can't go straight to citizenship. Green card, it has to be the first step. If you obtained your green card through marriage to an American citizen and you have or you're still with that person, you're not divorced, you're still together, and you're living in the same household, then you can apply for citizenship after 3 years. Even on the 3-year mark, we typically reach out to our clients about 6 months prior because we can technically file the application 90 days before the 3-mark period. If you received your green card application through other means, any other type of family-based application, you have to be a green card holder for 5 years. If you received your green card through asylum, there's a shorter period of time, about 1 year to 2 years. Same for VAWA. It just depends on the type of application, but there is periods of time that you have to wait before you can go through applying for citizenship.
Okay, if a person received health help years ago, or if they've received government help in the past, is that going to affect them?
So our understanding, and I can't say that they are going to hold up to this, because I'm going to tell you that we've had some crazy decisions that are arbitrary and capricious and definitely against what law states. But they indicate that they are not going to penalize people who've received the benefits before February 24th, 2020, because they did not have notice of this new rule. So whether or not they are going to abide by it, we still have to disclose whether or not they have received benefits in the past. We then have to state that it wasn't after February 24th, 2020. But remember that the officers are human and this is discretionary. So for any period that they've received public benefits in the past, we are going to need to have a good excuse on why they received them. If they received it for 3 or 4 months in the past and it was because they got laid off at the time and the company downsized or something happened, and then once their financial situation got better, they were stopped receiving the public benefit. That's going to be a way for us to mitigate. It's really going to be on a person-to-person basis. We're going to have to make those types of calls, but we're still going to have to disclose that they received it. And if they received public benefits for 12 months over a 36-month period, and it's definitely after February 24th, 2020, that is going to be considered a heavily negative factor. But it's going to be considered one factor. It's not going to be considered the sole factor in this determination. So we can still mitigate and show other positive factors.
All right, does this apply to refugees?
No. Refugees, asylees doesn't apply for. But typically, refugees are out of the country when they apply, and they come in with a green card. So that's something that's going to be done at the consulate. There is a separate form for the consulate for public charge. The rule is slightly less demanding, but it still goes over all these main 5 factors that I covered today.
All right. Are the immigration courts in Florida, as opposed to other states, friendly to immigrant petitions?
No. We are in the South. So it really just depends on where you're at, what judge you have. There is definitely, we get assigned judges randomly. I am not going to mention any judges' names, but there are some where we are like, oh no. And then there's some where we're like, okay, we have a pretty good chance. Does it matter? Absolutely. What judge you're assigned to is going to give you a better chance for a positive outcome. But remember that courts is different than USCIS, right? And this is what makes immigration so complex. There's the court system is a lot of times for the removability of or deportation of an immigrant. It's different than affirmatively applying for a USCIS benefit. That's done by an immigration officer. Are immigration judges going to have to do the public charge rule? Yes. And let me kind of give you an example of when that would happen. Sometimes you are in deportation court and you have been married to an American citizen this whole entire time. You qualify for a green card, but you just never applied. You couldn't afford to apply. It wasn't an urgency. And then you get picked up and now you're going to apply for that green card process within the court system. So we don't know right now how judges are going to handle the public charge rule. We actually, for administrative applications such as this, we prefer to be in front of a judge because they understand the law better. And this is not something like an asylum case. Or some other type of removability humanitarian type case. So they understand the law better. It's a lot easier to get a positive outcome for administrative type cases like a green card application.
All right. Are special circumstances considered, such as the elderly or people with disabilities? Will this apply to them?
Being over 60 is a negative factor in this public charge rule. So, really what they're trying to keep out is the too young to be able to contribute to society, the old and the poor. That is the whole goal of this new public charge rule. So if they're over the age of 60, that's a negative factor. So age is something that is considered. So they are going to ask whether or not you're retired, but just your age being over 60 or under the age of 18 is a negative factor. Yeah, disability is going to matter depending on what type of disability it is. That's going to be done on a case-by-case basis. But if you're receiving SSI because of disability or SSD, that might be something that's going to negatively impact you in regards to the public charge rule.
Are scholarships for children considered a negative factor?
No, it's not a public benefit.
All right. Hang on.
I would actually argue creatively that's a positive factor. It's a resource that you've earned. So I would argue in favor. I would definitely include a copy of the scholarship the grant of the scholarship, who it's provided by, why or how and why did they earn that scholarship. And yeah, I would use it as a positive. Obviously someone saw potential in this person.
All right. If you live in a household with an undocumented immigrant and that is found out, Will that be held against you?
Like if the person that they lived with was also undocumented?
Right.
We have not done that. Typically, they don't know that they lived there. However, now we have to disclose household and who is in your household. We would probably advise that person, if they're not part of the green card application, we might have them move to another address. We would definitely take precaution. We would not want to put them on the radar. We would have to have that conversation with them and see how comfortable they feel, what they're worried of deportation, and we wouldn't be able to guarantee that they would not say, oh, who's this person? Oh, they're not a United States citizen. Really, I don't know if there's any way for them to find out that they're not a United States citizen. It's not like we're disclosing social security numbers for each person in the household. But I would be overtly cautious. And I might say, is there a way that you can, live separately for a while? Or it really is going to just depend on the family dynamic, and that's a case-by-case basis.
All right. Is there any weighting scale regarding which factors are most important?
Some factors are more heavily positive weighted or negatively weighted. I think they're all important. Any little positive factor you can obtain or neutral factor you can obtain at this point, since we have not adjudicated any of these cases to its close yet, is going to be important. So I think they're all very important because it's a totality of the circumstance. And that's also going to be dependent on the officer's point of view. An officer might think that health insurance is really important. Another officer might think bank account is really important. I don't think that we can't really read the mind of the officer, so I'm going to say that they're all important.
Okay, for people trying to apply for a visa or asylum or green card from Venezuela where there isn't an American embassy, what is the process?
That's a really great question, and a question that we get quite often. You got to go to you have to get a consulate a neighboring consulate to accept your application at the consulate. And to do that, typically we have sent them to Colombia. We work a lot with Belize. Belize is a really friendly place, and they are willing to take people, because their office is not that busy in Belize, that they're willing to take other countries. They just have to go to another consulate. Same thing for Cuba. But an immigration attorney can help you through that process. We typically email the consulate, and we get in touch with somebody there, and we help them through the process of being able to get approval to apply at another consulate.
All right. At this time, if an applicant for naturalization has received unemployment benefits, will it count against the applicant in the interview?
No. No. Unemployment is not a benefit. It's an income earned. You file taxes on that income. So, in that stance, it's going to be important that they file for taxes, because you want to show good moral character and that you've done the right thing. If you're going to take subsidized income for unemployment, then I would strongly suggest filing taxes, because you really need to. This is not income under the table. It's not cash. It's unemployment. And when you go to apply for citizenship, you're going to have an issue if you were supposed to file for taxes and you didn't. and you owe money based on taxes. So for citizenship, there's a good moral character stance, and a couple of things that they look at is taxes. And then they also look at whether or not you owe child support, or even if you're not on child support, whether or not you're supporting your child. You know, they look at criminal background up to 5 years looking back, and a couple other things that they look at, DUIs. There's a slew of different things that they look for good moral character, but taxes are really important. And that's another reason why we are encouraging, if you're undocumented, file for an ITIN, file your taxes.
All right. What about financial aid for college?
If they're going to college, the only way that you can qualify to go to college in the United States is if you already have a green card, or you're here on a student visa. And if you're here on a student visa, you don't qualify for financial aid. You pay out of pocket. For a green card holder, I believe that you qualified for financial aid. I can look that in, but financial aid is not going to be considered a public benefit.
Okay, we have a few more questions here. Are the judges leaning towards disqualifying good candidates due to the push of putting judges in during this administration?
I really don't understand the question. So say that one more time.
Are the judges leaning towards disqualifying good candidates during the push of putting judges in during this administration? We can get to that. Sorry, go ahead.
For immigration court, the judges are not, we don't vote on those judges. Those judges are part of the executive branch. So part of the problem that we have with immigration is that the court is controlled by the executive branch. It's not an independent court. So the judges it's hard because the judges have very little freedom because they can't make full independent choices because they are controlled by the executive branch. That is one thing that AILA and the American Immigration Lawyers Association is fighting for, is independent immigration courts. We don't put those judges in. Judges apply, and the executive branch makes the decision of what judges they keep or they accept and get appointed, because they're really not judges. We call them judges because that's the respectful thing to do. They wear a robe, but they're not judges. Yeah, that's not their formal name.
Okay, our next question here is, what if the applicant for a green card is an undocumented person and is married to a citizen? Would the applicant for the green card have to return to his home country for the USCIS interview, or could it be conducted here in the US?
So there are 3 types of applications that have special treatment, and that is a US citizen sponsoring a spouse, a US citizen sponsoring a child under the age of 21 unmarried, and a US citizen sponsoring a parent. If they have been located in the United States this whole entire time and they have accrued time of being undocumented or time of working out of status, that time is forgiven. So they can do the whole process within the United States. For other family-based categories, that is not true. So if they are a green card holder and they're sponsoring a spouse, they don't have that same benefit. So they may need to consular process, but they're going to require a waiver because they're going to have to waive the time out of status they spent in the United States if it's a green card holder sponsoring a spouse. So there's a lot of complications to that. But for a U.S. citizen sponsoring a spouse, the whole process can be done here in the United States. But there's other factors to think about to make that decision. It's not black and white. It also depends, do they have a deportation order? What's their immigration past? Did they come into the United States? Because in order to do the process in the United States, you have to have what is called a legal entry. So you had to be inspected and admitted into the country. So if they married an American citizen and they their American citizen filed an application for them, but they crossed the border illegally, they're not going to qualify for a green card applying in the United States. They need to consular process and they need a waiver for that illegal entry. And if they have a removal order in court, it gets really complicated. So it's important that they speak to an immigration attorney before determining what their path is going to be.
All right, and we have one more question here. It sounds like we are in need of good immigration officers. Are there opportunities for these jobs? Would it be a good idea to encourage people to apply?
Yes. You know, I kind of think of the same way in criminal court. You know, everybody wants to be a defense attorney. They want to be able to do good for the people, especially for petty type crimes and things of that nature. And you hold more power as a prosecutor. You can decide when to drop a case, when it's not worth fighting for, or when someone deserves a second chance. I think it's the same thing when it comes to immigration. However, just know that you may get frustrated because in some situations your hands are going to be tied. However, you are going to have a louder voice. If you want to become an immigration officer, you don't have to have a law degree. Please apply, especially if you believe in immigrants and what they provide for our country.
All right, so that seems to be the end of our questions. Did you have anything else to add, Alice?
Yeah, if anybody has any questions or any immigration questions, say you just didn't think of something now, my phone number is on the screen. That's my direct line. So I will pick up myself and then, or email me. I'm happy to assist, you know, if your students have further questions or you end up talking to your students and you don't know an answer to a question, we'd be happy to help in any way that we possibly can.
All right, thank you all so much for joining us today. Thank you for your great questions. So I do want to let you guys know that we will be following up this presentation with an email. We'll include a survey in the email. If you'd please complete that survey, it really helps us kind of hone our professional development and make sure we offer high quality presentations to you all. And we will also be providing you with the link to this session recorded. So if you wanted, yes.
I do also want to say that we are a firm of 3 attorneys. We speak Spanish, Creole, and French. So just to let everybody know.
Yes, thank you so much, Alice. And if that's all, if you have any other questions, please feel free to email me, shoot me an email anytime. You all should have it already, and just keep an eye out for the follow-up email. Thank you guys again, and have a wonderful rest of your week.